Hello, everyone. I'm Jay Lazega. Welcome to this installment of L&J's Morning Break. We're glad you're here. We hope everyone is doing well. Thank you again for all the positive comments and well wishes and appreciation for these things and just saying hello. We love that. Love hearing from you. So today's session is uh, light at the end of the tunnel. Is it what we probably all believe, a train, or is it something more positive? A lot of things happening in the world. And today we have Pat Poe and Dan Wright. We'll get to that in a little bit. We're going to talk primarily about uh, the recent, essentially mostly reopening of the courts. The courts have expressed that they are ready to go. So we're going to talk about what that means in the real world and what we should be doing to move our issues forward with collections and enforcement. I'll also, at the end, we'll talk about the recent back and forth with Governor Kemp and some of the local mayors, Mayor Bottoms in Atlanta, challenging each other on mask orders and other things. Another Kemp executive order put out last night, so we'll talk about that at the end. But today we're going to talk primarily about the courts. A couple of quick reminders. If you haven't already, check out our resources on our website at ljlaw.com, the resources section. Share those with your boards. Great stuff. Sample signs and rules for those of you that have opened your amenities. Sample letters to owners explaining why you haven't, or talking about why we're not going to refund assessments because we haven't opened amenities yet. Sample signs, feel free to use all of that. Sample waivers. And also visit our Facebook page and our YouTube channel. We've actually on the YouTube channel have dozens and dozens of great videos on other issues for communities, not just these, but Airbnb, insurance, maintenance. So feel free to visit those. We encourage you to use those. So we're going to get started now with Pat and Dan. Guys, welcome. Go ahead.
Hello. I hope everybody's doing well today. Have a couple of interesting topics that I think that everybody that has joined us today will be interested in. I'll be starting off here first and talking about the new judicial order that was entered on July 10th. The Chief Justice of the Supreme Court entered an order. This is his fourth order regarding the judicial emergency. And what this one does, it's probably the most advantageage for all of us. It gets everything moving, at least it's hoping to. Basically what it says, the key provisions for community association cases are that the deadlines began running on July 14th. So any case, what that means is that any case that was pending before March 14th, we still have that same thing, that the defendant will still have the same amount of time they had on March 14th to respond. And then cases that were filed between March 14th and July 13th, in other words, those during the judicial emergency order, the deadlines started running yesterday, or the 15th, I'm sorry. So basically complaints that were filed during the time of the judicial emergency order, if we filed a new case during that time, the complaints filed during that time will have their answers due on August 13th. But they will also still have an additional 15 days, so we can't default before that, because they can open the default as a matter of right. So technically, August 31st, because it will be the 15th day after the default period will be on a Saturday. So August 31st will be a big day when we can start filing for a lot of defaults. So hopefully that will start moving some of these cases through the pipeline. Any cases that were filed after July 14th will proceed as normal as far as deadlines go. So basically what this is doing is it's getting everything that's in the pipeline and that's being filed now, it'll be starting to move forward. Now, another key provision of the judicial emergency order that was filed on July 10th also has to do with what we're using now, remote technology. The courts have been decreed to continue to use and hopefully to increase their use of remote technology. So Zoom, GoToMeeting, things like that are going to become more and more common. Courts have been given the power to compel participation in remote proceedings. So, you know, a lot of attorneys, I've actually seen it, and Pat probably has too, where some attorneys say, well, I'm not very technologically savvy, so I would rather have an in-person hearing or maybe a telephonic hearing. Courts now are going to have the power basically to say, look, you need to read the user's manual on Zoom and go to meeting and participate in these hearings in a remote fashion. So that's a pretty big deal. So if you have not been using your remote technology, you might, and you're going to appear in court, chances are you will be doing so just like we are today on camera. Courts do have the power, though, to also reinstitute in-person proceedings, but there's a big provision there in the order that says the court cannot compel attendance if the hearing or the court facility is not in compliance with the public health orders that are in place. And I believe, I know at least right now we have 2 courthouses that are pretty much closed because they've had people test positive for COVID, things like that. So they have closed the courthouses in those counties, and that may continue. That's going to be kind of on a county by county basis. I believe DeKalb and Gwinnett right now are closed until the early part of August, if I'm not mistaken. But so really what it is, it's kind of like most things in general, that courts can impose more restrictive measures if they need, but they can't really go and relax the restrictions that have been put in by the Supreme Court in the judicial order. So what does this mean in reality? Basically, it means litigation is going to start flowing again. We should expect more use of remote technology of all types, again, like Zoom, GoToMeeting, things like that, and that you should be getting familiar with those if you're not already and how to use them. But one thing that we do need to keep our eye on, and this is kind of where the title of this came from as far as that light at the end of the tunnel, is that the courts are going to have a very significant backlog of things that have been filed during this judicial emergency order. An example of this is Fulton Magistrate Court issued an order a day or 2 ago here now that basically started talking about how they were going to proceed forward, and they have suspended all in-person hearings until at least November 2nd. So that can kind of tell you where one of the most populous courts has their mind as far as how they're going to be proceeding forward. Another thing that was pretty important in that order is that they recognized that at the time the judicial emergency order went into effect back in March, they had 2,535 cases pending. Since that time, they have had 6,500 additional cases filed that they have really not been able to move at this point. So basically what this is telling us is that even though the restrictions are being relaxed and that the gates are going to be open, I don't know that we can expect a flood at this point. I think that getting cases in sooner rather than later is going to be highly advantageous. So if you have anything you've been thinking about holding on to and waiting to send to us, please send to us as soon as you can, because the sooner it gets in, the sooner it's going to get addressed. And now, even though we are able to have the deadlines moving and start moving toward getting some resolutions, don't expect them that they're going to come particularly fast, because there's going to be a lot of backlog. So don't expect a flood, expect maybe more like molasses to flow through these floodgates. But at this point, hopefully we can see that light in the tunnel. It's going to start moving things in the right direction, and we can get things going for all of our clients. So with that, I'm going to hand it over to Pat, and take it away, Pat.
Thanks, Dan. I'm Pat Poe. I'm with the litigation group here at Lazega Johanson. I handle litigation that's not collection related. That usually means enforcement and defense of associations and directors and officers when they get sued, or if there's a counterclaim or something of that nature. More to Dan's point, and I completely agree, and it's applicable not only to collection cases, but to all the lawsuits we're handling. It's important to get in line, because while it may be a flood of molasses, it's going to be a lot of cases that the courts are going to be dealing with. And from what we've seen, typically they're going to deal with cases in order. So if you've got cases that need to get in line, get them in line, because that's going to make it easier and more likely that we're able to get an order from the court sooner. For example, if there are violations that need to be dealt with, they need to be dealt with sooner rather than later, so that we can get in line. So that's on that court issue. The other thing I was going to say is another part of the courts gearing back up is we're in a position now to put more pressure on the other side. by pursuing things like discovery and depositions and filing motions for summary judgment, because for the past couple months, responses to those kinds of things have been stayed. Now we can start putting some heat on the other side and start making the cases move forward. And that gets cases resolved. I wanted to talk also a little bit about claims against the association. As I mentioned, and as a lot of you know, I handle insurance defense. I'm retained regularly by insurance companies to defend associations and directors and officers. And we're seeing cases, and we've been retained on cases with claims by owners for damages for not opening the facilities. We've talked a lot about the risks and concerns about claims by owners for opening the facilities, and I know that's been addressed before, and there's different issues with that. But we're also seeing claims by owners for not opening the facilities. We think, generally speaking, those are very defensible claims. And low risk claims, by low risk, I mean the damages at risk really aren't high, but we're seeing those kinds of claims, or we're being retained to defend them so far. Those kind of claims are typically owners seeking a refund of their assessments, or they're disputing assessments, saying they don't have to pay them because facilities weren't open and they didn't get to enjoy the pool or the tennis courts. And then sometimes they make some sort of claim for loss of use of the ability to join the pool or enjoy the tennis courts. You know, that compared with the kinds of damages folks are claiming for actually contracting some sort of illness like COVID-19, obviously we think the risks and the defense risks of that are lower. But they're out there. Those claims are being made, and you should be aware. I've said this before, and I'll say it again. The issue there is boards just need to make good business judgment decisions. They need to make decisions that the courts will look to and question whether the decision was reasonable, whether it was arbitrary, capricious, made in good faith or bad faith. So if the board can articulate a good faith reason, a reasonable reason for the decision they made, like we didn't open the pool yet because, then it's probably going to be defensible. We didn't open the tennis courts because it's probably going to be defensible. On the other hand, if you are going to open those facilities, as we've explained in other of these sorts of sessions, there are reasonable ways to do that. And you've got to do that in an orderly and careful fashion. But from a defense perspective, these cases that are claiming that the association should have opened the pool and they're claiming damages for not being able to use the facilities, we think they're highly defensible because boards are making reasonable decisions, and we think the risks of damages are, relatively speaking, low. What harm or what provable damages is one going to be able to show for not being able to use the tennis courts for a period of time, or not being able to use the pool? We think it's a relatively low amount of damages, if any. If they were to be able to prove any liability whatsoever, they still aren't going to be able to prove much in the way of damages. And again, liability is really going to look to whether or not the board acted reasonably in making its decisions, or acted arbitrarily or capriciously in making its decisions to open or close the pool. It's not an easy decision. Many boards, many associations, many members of associations are demanding to open facilities. And so if you do so cautiously. We have, as Jay mentioned, we have information on our website that talks about opening pools and assists with documents that will help with opening pools. We also have information about keeping facilities closed. And in particular, there's a good letter on our site that you're welcome to use. And it addresses disputes, or is a response letter to an owner who is disputing assessments or asking for a refund because the facilities are closed, basically explaining that you owe your assessments regardless. And the law in this area is quite supportive of associations. The law is quite clear that assessments are separate. Assessments are owed regardless of whatever dispute the owner might have with the association about opening facilities or not opening facilities, about maintenance of property or not maintenance of the property. The law is pretty clear in Georgia that those issues are separate and that folks owe their assessments regardless. And that makes sense because assessments keep the association moving. Other disputes can be dealt with separately. So we're seeing circumstances change in the courts and on the ground. So it's really important to stay current with the information, stay agile. If you receive anything that looks or smells like a claim from an owner about anything, demanding that the association do or do not do something, it's probably a good idea to notify the insurance carrier and see if it might be a covered claim. And so with that, we say let us know if you have any questions. I hope this session was helpful to you.
Great, thank you guys, that was great. So we've talked a lot about the issue of exclusion of communicable diseases under most or many liability insurance policies. But on the other side, we've also talked about the thought that our D&O policies should cover our decisions to not open or not open yet, or open in restricted or limited manners. And the great news is we're seeing so far in those, we can talk about how offensive we think those owner claims and demands are for refunds and assessments because we haven't opened the gym or swimming pool. But the insurance carriers so far are stepping up and saying, yes, the directors and officers liability insurance policies, carriers. Yes, of course, we're going to defend you on those. So that's great news, following what we thought should happen. So a couple of other quick things we've talked about, and you've probably heard about Senate Bill 359 in the Georgia legislature that made it out that some think is the absolute protection, liability protection for us in opening amenities. It certainly will help, but it is not law yet. Kemp, we don't know why, but Kemp has not signed it into law. And if he doesn't sign it into law and doesn't veto it, it won't become law until August 7th, I believe was our date. So it will help us eventually, but it is not the law yet. It's not the protection. We need to continue to follow appropriate protocols if we operate and just be responsible. We are anyway, but we need to remember that we've got risks in operating our amenities. Okay, Kemp also put out an order last night, another executive order that basically follows the earlier ones, but it was in response to many of the cities putting out mandatory mask orders, essentially. City of Atlanta, I think Athens, I think Savannah did, a number did. And Kemp reissued his order extending the extending the state of emergency through July 27th, but extending through, for a while, through the end of the month at least, the continuing obligations to sanitize and some social distancing, but permitting gatherings of up to 50, much less restrictive than the cities have done. And Kemp specifically said in that order, you cities are not permitted to make mask orders, essentially. The cities may continue to enforce those anyway, and we may get into a battle between the cities and the governor. We'll see what happens. But individually, we still have authority as communities to establish regulations for use of our common areas. And generally, if we want to, and I believe in many communities, in many circumstances we should, we believe we have the ability to establish our own mask requirements. So that's something we've got some more information on our website, and we'll talk about more, but something to keep in mind. Last, many of you are signed up for our July 21st continuing education class, and it is on annual meetings, annual and board meetings. And the focus will be essentially, we have to have annual meetings and we have to conduct elections. We don't get to just not have them because of the pandemic. And we will not have them in person this year. You're just not going to do that. There are other methods to do it, whether they are voting for directors outside of the meeting by ballots or online methods, video or virtual meetings. This class is going to talk about specifically how to do it. Very practical to help you how to do it. We got 300 people in this class already. It's filled up, but we're going to add another class in August to invite board members, and we're going to have a much greater capacity for that class. So definitely look for that. Definitely join us. If we are going to use these other methods besides an in-person annual meeting, we need to get started with the planning really within the next 30 days. So put that on your calendar to start talking about it. Your next board meeting is very important. Okay, we miss you guys. We hope that we get to see each other again soon. In the meantime, though, stay safe and healthy, and take care. Thanks for joining us.